A Mississippi transfer on death deed is an estate planning tool that can be used to convey property to a designated beneficiary upon the property owner's death. This document allows the property transfer to skip probate proceedings. To be valid, the form must be executed, acknowledged, and recorded before the owner's death. In this video, we'll cover the difference between a transfer on death deed and a will, legal requirements for recording a transfer on death deed in Mississippi, and how to revoke a Mississippi transfer on death deed. We're eForms, the world's largest online database of fillable legal forms, and we're here to make complicated legal issues simpler and less overwhelming. To begin creating your own Mississippi transfer on death deed, click the link at the end of this video. Let's start by comparing a transfer on death deed to a last will and testament. Both documents can be used to convey property, like a home or a plot of land, to a designated beneficiary upon the grantor's death. However, the key difference is that a transfer on death deed skips probate, while a will is subject to probate. What's probate? Probate is the process of analyzing a deceased individual's assets and debts and then distributing what remains. Though this may sound simple, probate is normally a long, drawn-out process that can be quite stressful. Since a transfer on death deed skips this process altogether, you can save a lot of your descendants a lot of time, money, and heartache. But how do you complete a transfer on death deed in Mississippi? The form itself will ask for your basic information like your name and the designated beneficiary's name. It will also ask for a legal description of the respective property. Unlike an address, this description delineates the property's exact location, boundaries, and physical qualities. To find a legal description, reference property tax statements and the current deed. The Chancery Clerk of the county should also have access to the legal description. After completing this transfer on death deed form, it's time to get it notarized. From there, it must be recorded in the deed records of the Chancery Clerk of the county where the real estate is located. This must happen before the property owner dies, otherwise the deed won't be considered valid. If you ever change your mind or need to revoke the transfer on death deed, you can do so by completing a form of revocation. This form must be notarized and recorded with the Chancery Clerk of the county, or completing a new transfer on death deed. If a new transfer on death deed is executed and recorded in the same county as the previous deed is nullified. If you're ready to get started on your own Mississippi transfer on death deed, click the link below. Also, be sure to subscribe for more legal content.